So this does relate to the Sevier County case, in that Mr. Click was charged in the Knox County case for conspiracy to distribute 150 grams or more of heroin within 1,000 feet of a school zone. And part of that distribution was alleged as it relates to what was going on in Sevier County. So I did represent Mr. Click in the trial court below. Again, my name is Wesley Stone. I do represent Mr. Click in this petition for a writ of.
May I ask one other question?
Yes, sir.
Sorry to interrupt.
No, it's good.
So are these sentences concurrent? In other words, the two county sentences are concurrent?
So he was sentenced in Sevier, yes. The answer to the question is yes. He was sentenced in Sevier County first, 80 years, and then we were sentenced in Knox, 25 under the drug-free school zone, concurrent with the 80. Yes, sir.
Thank you.
And so by virtue of him being charged in the Knox County case, it was 150 grams or more. I think it was 150 grams or more. Anyway, it was a Class A felony. So the drug-free school zone really made no difference until you get to the mandatory minimum sentence under the old law that was required to serve within that range. Then it makes a big difference. And it makes the same difference that we've sort of argued in the other case. So he was charged with an A felony in Knox County. They did seek the drug-free school zone enhancement. They did not. They did seek the drug-free school zone enhancement, and he was sentenced by the judgment, I think it's volume 1, page 35, to the drug-free school zone. 2022 amendment comes out, does not apply to him. 2020 amendment comes out, does not apply to him. 22 amendment makes it retroactive. And I find it, as I was preparing for this today, I think this whole, I think the appeal, I think the court's ruling in this will really center on, not exclusively, but will center on the phrases sentence, minimum sentence, and period of confinement. The state, in their brief, takes the position that under the new law, that there's really no change in the period of confinement. And that is the position that the trial court took when it held in its order that the drug-free school zone did not increase the level of offense, only the minimum sentence that must be served before the defendant may be considered for release. The defendant was a range 2 multiple offender. He received the minimum sentence of 25 years. The court goes on to say, this is a trial court, in this case, the defendant could not receive a sentence shorter than 25 years. I agree. But what's interesting, when this court looks at 3917-432, A through G, it all speaks to sentences, minimum sentence, and things of that nature. Then when the General Assembly makes it retroactive to sentences occurring prior to that statute, in section H, it speaks to period of confinement. And I don't want to get into the all apple trees or trees and the things that we do, perhaps just what we do. But I will say that ask anybody who is serving a felony sentence who is eligible for parole, and they will tell you they are serving a period of confinement. So periods of confinement are parts of a sentence. But it's our position that the General Assembly, when they codified subsection H and makes reference to period of confinement, that they were speaking to what someone was actually serving. And I go on to reference this court to subsection 3917-432 H3B. And there it reads, and I'll cut through some of the other stuff, but as applied to Mr. Click, the court shall not entertain a motion if resentencing the defendant to a shorter period of confinement for this offense would not lead to an earlier release. As it relates to Knox County, exclusively Knox County, this use of the phrase period of confinement as opposed to minimum sentence it's our position that the court shall entertain a motion if resentencing the defendant to a shorter period of confinement would lead to an earlier release. And in this case, it would. The state takes a position, well, if it's a Class A felon on the Range 2, sentenced pursuant to the judgment of a drug-free school zone violation, that really, it doesn't change much for Mr. Click. It really doesn't change anything. Well, it does. He's 100% now. If he's eligible for parole, 35%, that's 8.75 years, as compared to the 25 years he's currently having to serve. But that's a period of confinement. And it's our position that when the General Assembly passed subsection H, they were considering not only prospectively what may occur from sentences after that, but more importantly, what was occurring prior to that specifically. If there's ever a statute that was designed for a particular person, perhaps 3917-432H was designed for Mr. Click's case. But be that as it may, if you rewrite Judge Sword's order denying resentencing, which there was no evidentiary hearing in the Knox County case.
I wanted to ask you about that, Mr. Stone, because the state seems to say there was. As I read it, it appears there might have been a truncated one or a semi-hearing of sorts. Could you describe that for us?
Yes. So what happened at that hearing, the parties were before the court. General S. Ball was representing the state. And the question that I presented to the court is, I don't know which comes first, the chicken or the egg, recognizing that he did receive the minimum sentence for a Range 2 Class A felony, and recognizing that subsection that creates that there's a rebuttable presumption that you don't have to serve the minimum sentence within the range at 100%. Are we going to have a resentencing hearing? And the court heard my argument. The court heard General Eschball's argument, and then said, I'll review this and I will render my report. So there was no evidentiary hearing. I did make reference to some exhibits. They're the same exhibits that we offered in the Sevier County case about his treatment in the Knox County Sheriff's custody, pending these motions. But there was no evidentiary hearing. And the trial court even made comment that Mr. Click, his best, perhaps if not only really recourse, would be through a clemency through the governor's office. The court may walk away from this hearing, and perhaps in the light of Parker, and wonder if there was a clemency request. In anticipation of perhaps that question, I did reach out to the Department of Corrections. Mr. Click did make a request in 2020, and when speaking with the representative earlier this week, she said that it was COVID. It took a couple of years, and they sent something back to Mr. Click saying you need to do your narrative better or something. There's some part of that request. So there's been no action by the governor's office as it relates to clemency.
But that application was, it sounds like prior to December 2nd of 2021.
Judge, I'm not sure. I was not involved in that. I'm not sure when that application was made. I don't know.
Okay.
I don't know.
I thought I heard you say 2020. I may have misheard it.
I was not involved in that. If I said that, I misspoke.
See.
But if you read the second page of Judge Sword's order denying resentencing, and you substitute period of confinement, everywhere Judge Sword has used the word sentence, we should win. This court should grant Mr. Click's petition for writ. And I know that the state has said in their brief, and I'll address this now and perhaps maybe have some comments here in a moment, they take the position that we did not prove that Mr. Click would be sentenced to a shorter period of confinement. Well, it's our position that 3917, 432 H1, which has that requirement, is satisfied when you look at 3917, 432 C, which states, notwithstanding any other law or sentence imposed by the court to the contrary, a defendant sentenced for a violation of subsection B may be required to serve at least the minimum sentence. And it's the discretionary may in that particular provision. You go on down, C2, there is a rebuttable presumption that a defendant is not required to serve at least the minimum sentence. It's our position, by virtue of the law, we've established that he would otherwise be eligible for a shorter period of confinement.
What does that first clause in H1 mean? When it says notwithstanding subsection D or E or any other law to the contrary, it's referring to D or E, which is talking about the 100% service on a minimum sentence. So what did the legislature mean when they said notwithstanding those subsections?
Well, subsection D provides that whatever 4035, 501 speaks to parole eligibility does not affect what happens in 3917, 432. That's the way I interpret perhaps that. Section E, I think it speaks to the governor of the Board of Parole releasing people. And I think what this is saying is that this court, a trial court has the ability to re-sentence someone. I think that whole thing starts with, we're going to give trial judges an opportunity, now that the law has given them some discretion in sentencing, to be able to do that, in addition to perhaps the parole clemency opportunities that a person may have. But I read on that H3, when it speaks to subsection C and applying for governor for a grant of executive clemency, the court's not supposed to consider that. I think you have to exhaust what Mr. Click has exhausted in the trial court, perhaps in this court, to then seek the executive clemency. Otherwise, the trial court doesn't have jurisdiction.
To kind of boil it down a little bit, I mean, isn't the question what constitutes a sentence? Because I'm reading Judge Sword to say a sentence is just the term, the length of the number of years in the sentence. It's not the release eligibility date. That's not what subsection H contemplates. And you're saying that it does. So isn't that the real question at the end of the day? What is the sentence?
Well, the sentence is 25 years. I mean, that's the sentence. Manner of service is he's not eligible for probation, so it has to be served. I think the question becomes, why would, and this is perhaps I'm not asking the court a rhetorical question, but I'll pose it for myself to answer it. Why would the General Assembly create a rebuttable presumption for purposes of resentencing that a defendant is not required to serve at least the minimum sentence in 3917 432C when it passes subsection H? And it's our position so that the courts can address the periods of confinement. Well, what is the period of confinement? It's the period the person is serving in custody. Range 1, he's serving it at 30%. Range 2, 35. Range 3, 45. I don't remember the 40 maybe. Career offender, 60%. But it's speaking to the period of confinement. And that's what we were challenging in the trial court. That's why we think the judge abused his discretion in not addressing that. And so our best day, I put it in our brief, but our best day would be if he's an A felon, range 2, it would be 25 years at 35%, which is 8.75 before he's eligible for parole. Looking at that in the context of just a Knox County case. I hope that answers the court's question.
Yeah, a little bit. As I'm reading, what I'm taking from Judge Sword's order, he's saying, well, the statute requires a showing, because what the statute says would not reduce the defendant's overall sentence or lead to an earlier release. And I'm hearing Judge Sword saying, well, he could get a 35% service rate, but he's not guaranteed release at that date. It's just his eligibility date, right? So Judge Sword is saying the defendant here cannot show that he would get an earlier release on this date. It's somewhat speculative. Am I reading that correctly?
Sort of. The period of confinement would be at least 8.75. But let's assume for a minute he's subject to a 35% sentence as opposed to the 100, where you cannot get sentence credits. The likelihood of Mr. Click on that particular sentence having to serve 25 years as a range 2 multiple offender and serve those 25 years, that he's going to get released sooner than 25 years under our argument. Under how it stands right now, he's not. But it looks to the period of confinement. And I agree with Judge Swords. Who knows what the Board of Probation and Paroles would do? Who does know what they'll do? To a point. But we know at least the period of confinement is 8.75 years, which on a 25 at 35%. But as it stands right now, he doesn't get any sentence reduction credits, even under the new revisions of 432. It looks like I have entered into my rebuttal time, so I'll yield the floor, and we would just ask that the court grant the petition, send the case back to the trial court.
May it please the court, Catherine Redding on behalf of the state. The defendant's appeal should be dismissed. Because he has no right of appeal under Rule 3 or under the statutes, he is proceeding under a petition for writ of cert. But as we've previously discussed, that is an extraordinary remedy, and the circumstances in this case are not sufficiently extraordinary.
Well, what if the trial court denied him a hearing on the merits when the statute said that he was supposed to get a hearing on the merits? Isn't that denying his day in court?
I agree that that would be a denial of day in court. I don't think that that's what the record shows, and I didn't understand the defendant to be arguing that he was denied a hearing. The way I understood the record, and obviously the record will speak for itself, was that they had a hearing, and unlike in some cases where the question is the interest of justice, the issue here was the first threshold question of whether the defendant would be sentenced to a shorter period of confinement. And so that's what the hearing was on.
I think what he's saying, I think we're all kind of saying the same thing. I believe Mr. Stone is saying they were having a hearing to decide whether they were going to have a hearing on the merits of resentencing, to see if the statute allows for them to proceed to that question on the merits.
Sure, and I think if we're having a hearing to decide the first part, then, so if you have a hearing to decide the first question, then the answer has to be yes, he would have, and then you would have a second hearing. But because the answer is no, he's not entitled, because he failed to show he would not have, a second hearing wasn't required. So I think given that I don't know if that made any sense, but given that the issue in this particular case was the first threshold question, and the answer to that question was no, that kind of cuts off. There's no need for a further hearing. Right. So I think the record will speak for itself. I think that they had the hearing that was necessary given the particular circumstances. So I do not think that the defendant, under these circumstances, can say he was denied his day in court. Obviously, if the court gets into the record and it finds something different, then that argument doesn't survive.
Okay, so what if the trial court was wrong? What if Mr. Stone's correct here and the trial court was wrong about the applicability of subsection H to this particular circumstance, would a writ be appropriate in that instance to address that shortcoming?
So if the trial court was wrong about part one, would it be a denial of a day in court? I don't think so, because of the language that talks about the writ and the kind of inquiry into the intrinsic correctness. And then you get into the plain and palpable abuse of discretion, which I would argue is a bit more, if we get to your spectrum of the where people fall, but they're all kind of in the same range. A plain and palpable abuse of discretion is outside the range. Like, I can see this, it's especially palpable, the definition of palpable. It's ding, ding, I only have to look at this B1 piece of paper and I know that we have a serious problem. And I think that given the absence of case law on this, I don't think that you could the defendant could show a plain and palpable abuse of discretion. So I don't think so.
It's a different section of this. Oh, I'm sorry.
No, go ahead.
I was going to say, but it's a different section of the statute where the writ can be granted, right? I mean, we're here talking about whether the defendant has the right to have a hearing, right?
Yes.
So if I'm not saying the trial court was, but if the trial court was in error with respect to that first determination, shouldn't there be a hearing?
Well, I think maybe it's helpful to go back to, I think it was Parker, where the court did not have a hearing because it misread a statute. I think there's a distinction between misreading a statute that I think in that situation, the statute was fairly clear that if the, and I may get this backwards, but if the governor, if you request clemency and the governor denies it, then no hearing, period. And then the issue was, well, partial grant versus
Right.
denial.
Yeah. Well, let me put it to you this
Sure.
way. Mr. Click is over here with a 25-year sentence, which we all agree is not going to get reduced
Yes.
by its term. The length of the sentence is not going to get reduced. If the trial court had reduced his release eligibility to 35%, would that have been allowable under subsection H? Does this statute authorize the trial court to do that?
So the statute says that the defendant has to establish he would be sentenced to a shorter period of confinement. I think the state's position is that the 25 years wouldn't have changed, but the would be. So the release eligibility date is just a date where you can be considered for parole. And if the combination of would be sentenced to a shorter period of confinement, kind of the, I don't want to say tenuous, but I mean, it's all conditional. It's like parole eligibility, you're not, it
Which
just
is what Judge Sword was kind of hinting at a little
Yes.
bit. He's saying, look, we don't know if he's going to get it or not. And under that calculus, there would be no way for a defendant ever to show that on this question. I mean, if they bring in a certification from the Board of Parole that says we guarantee we're going to let him out, which is not going to happen, obviously.
I think that the only way to meet the requirements under this section would be if you can show the number of years would be reduced. So this defendant is in a position where his convictions were Class A felonies regardless. They were going to be they were not enhanced to a Class A. They were Class A. He got the minimum sentence. So if it was somebody who was charged with a Class B, but it was enhanced to a Class A, obviously they can show that they would have been,
Sure.
they have a better shot of showing that
Sure.
would have been reduced.
But you're saying they can't do it when we're just talking about the release eligibility date.
Yes.
Let me ask you about the language in H3B, which is kind of what we're talking about here. It would not reduce the defendant's overall sentence or lead to an earlier release. So it's talking about the defendant's overall sentence or lead to an earlier release. If we're talking about the sentence in the first part of that, what are they talking about on the second part? Why is that language necessary if you've already discussed the defendant's overall sentence?
I'll admit I don't have a copy of it.
If your argument's correct, have you found it there?
Yes.
If your argument's correct, why wouldn't the legislature just have stopped? Why wouldn't they not have stopped after overall sentence? If that's all we're talking about is the length of the overall sentence, couldn't they have just stopped there?
I think they could have stopped there, but they decided to.
But they didn't.
But they didn't.
So what did they mean by that extra language, lead to an earlier release?
How does your argument not lead to that language being superfluous?
I think that you have to, I think that what, given that this language appears in when the instructions to trial court about when they shall not entertain motions, I think that it is a directive to trial courts that you need to take this up. You need to have a hearing. So, and then you go to the other section of the statute, 432H1, where then it talks about the burden. So I think that this is, the way I read this, and frankly I did not brief this, so I would hazard a guess, but would prefer to have a supplemental briefing if the court would like to explore this.
Back to H1 then, what does that first clause in H1 mean? Notwithstanding subsection D or E or any other law to the contrary, with D and E specifically talking about the inability to have early release on a minimum sentence, why would they reference those subsections right at the top if we're now saying, well, this doesn't apply to release eligibility dates? Or what, I shouldn't imply what that means. You tell me, what do you think that means?
I think that it means, I think that the earlier section, I think it means that the court should have a hearing. And I think that it is directing the court, it wants trial courts to have hearings on these motions. I mean, the circumstances under which a hearing is not appropriate are fairly limited. So I think that it wants defendants to be able to present a claim and be heard on their claim. So, but then I think given the language, they've established a two-part test for determining the availability. So I think it's it may be inconsistent, but I think that the language where it talks about the availability is what controls, because that is where you get into the merits of the claim and the nitty-gritty of it. And if you can't establish, when it said the legislature chose to use the phrase that the defendant must show he would be sentenced to a shorter period of confinement, it's that would be that controls, because now we've gotten past the threshold of having a hearing. We've gotten into the, how do you establish that you are entitled to, or that resentencing is available to you. So, but and even here, the next step would be, we'd have to have the next step. So even if the defendant had shown that the sentence that he would have received would have been sentenced to a shorter period of confinement, which the state doesn't think that that can be showed with a kind of tentative release eligibility date, then you still have to make the next step. So,
how does the concurrent alignment of this case with the Sevier County cases affect that? We're talking about, could it lead to an earlier release? Are we supposed to view this case in isolation, or are we supposed to view it in conjunction with the concurrent cases? Because if you view it in conjunction, this case is concurrent, it's not going to, you could dismiss this case and it's not going to lead to an earlier release. Are we supposed to view it that expansively?
I don't know that the legislature spoke to that. And I'd certainly say that the trial court did have that in mind when it was considering, given the comments on
That was not the ground the trial court relied upon. The
No.
trial court said, this doesn't apply to release eligibility date. So that's why I'm asking, well, then why is the legislature referring to the subsections talking about release eligibility date if we're now saying that it doesn't apply to release eligibility date?
I understand. And state's position is that those other, they get you to the hearing. They get you to have a hearing on your motion for resentencing, and then the legislature has set out very specific guidelines about what you have to show in order to get relief, the first step that you have to show. I'd have to ponder I don't know that the legislature intended for this sentence to look at the Sevier County sentence with this sentence, given that these were run concurrent. I mean, it's not on the judgment sheet, so it's really, I don't know that the trial court, the trial court obviously aware of it, but.
Yeah, to what extent, I'm sure the trial court was aware of it to some extent, but to what extent the record may not reflect that?
And I don't think that it does here. The trial court record is in the appellate record. So it could be, and I can't recall whether the judges were the same, but there is some indication. I mean, obviously the trial court was aware of it and that it mentioned, well, you still have Sevier County's 80-year sentence, so.
Is it unusual, I mean, this whole amendment process that's been taking place for the past almost 5 years now, somewhat extraordinary and unusual, I think, unusual probably a better term, that we've sentenced all of these defendants over the past however many years under this Drug-Free Zone Act, and then the legislature comes in and creates a way to re-sentence on otherwise final judgments. That's an unusual procedure. Would it be odd that the legislature would decide to give that grace to these defendants, but not to include the release eligibility aspect of it, to only limit it to the sentence?
I don't think so, given that the legislature did not provide a method of appealing the denial of resentencing. So they clearly were concerned they wanted to provide some grace, but not all of the grace. So I think the fact that there is a limitation is actually consistent with other parts of the statute.
So they would exclude any resentencing on what I would call park zone enhancements, non-school zone enhancements, the ones where you cannot increase the sentence, you only increase the release eligibility date. Under your reading, subsection H would not apply to any resentencing towards a park zone, because all you're talking about there is the release eligibility.
So I think that, this goes back to a question you asked earlier. I think that somebody who's convicted of a Class A felony, where it's a Class A felony because that's what it is, not because it was enhanced to a Class A, can only show that they would have been sentenced to a shorter period of confinement if they can show, if they were sentenced to more than the minimum sentence. I think that's probably the only way to do it. I'll say I may sit down and think of some other way you could do it. But I don't think that those limitations, I don't think the fact that this isn't that there are limitations to the largesse that the legislature decided was appropriate under Drug-Free Zone Act, I don't think that that is inconsistent or unfair.
What about the fines? Enhanced fines, could they be reduced?
I'd have to look back at that. I didn't look at the fines in preparation for this since they weren't at issue. But if there are no further questions, the state asks this court to dismiss the appeal or affirm the trial court's decision. Thank you.
I feel like I'm winning, so I'm going to stop. I don't know that I am.
Don't read into my questions. They always say, don't do that.
I know. I'm kidding. But that is one of the reasons why I thought it prudent to point out to the court in our argument that subsection H came in 2022 to deal with what was happening prospectively with sentences occurring after 2020. And I do think that and I would just reiterate that I think that the Knox County case has to be looked in isolation from the Sevier County case, to answer your question.
Because that would, if you didn't do that, it would be a deal breaker from your perspective.
Well, right, but I feel like also that Mr. Click's situation is kind of an outlier. I'm no statistician, but I think that to have the situation that we have here where we've got a substantive charge in Sevier County, which is not a basis for the conspiracy in Knox County. They did not allege in Knox County that these transactions in Sevier County were part of that conspiracy. It was all, I'm not exactly sure what that was, but that ship, I guess, has sailed. But I do think we're in a unique situation where we're dealing with two separate cases, and the statute 432 was designed to deal with a specific sentence as it relates to a specific case, as it relates to that specific conviction. So with that being said, be happy to answer any more questions, but I do believe it's to be considered separately. I just want to make that. Any other questions? Thank you. I appreciate it.
Thank you all for
Thank
sharing.
you, counsel.
Anything else on the docket? All right, and we're adjourned until the February docket.
All rise.